If you have been pulled over for a DUI and the officer has marked you as a chemical test refusal, or you remember hearing an officer talk about getting a warrant from the judge to get your blood, or if perhaps you weren't the nicest you could have been to the officer at the time when you were arrested for a DUI, you want to watch this video. We're going to talk about DUIs, DWIs, and refusals. In Indiana, if an officer has probable cause to believe you've operated a vehicle while intoxicated, he is legally obligated to offer you a chemical test, usually breath, sometimes blood. And while it sounds like a request, it's effectively required under Indiana law. Now, here is the trap, because if an officer reads you the Indiana implied consent statute, I have probable cause to believe you operate a vehicle while intoxicated, and now must offer you a certified chemical test. There's a few more words to it, but that's effectively what he's saying. If you say anything other than yes, unqualified yes, the officer can easily mark it as a refusal. I'm going to give you a few examples of that. If somebody hesitates too long before answering, the officer can mark it as refusal. Can I think about my options, officer? Can I possibly call my husband? Can I call you're taking too long. What's your answer? I just don't know what to do. Refusal. And the courts uphold that consistently. Number two, again, too many follow-up questions. Well, how many is too many? It's what the officer says. We have body cam of refusals, and basically, I don't know what to do. Officer, what would you do if you were in my shoes? Officer, can I call my attorney? Officer, can I just take a second here to figure out what's going on? The officer has a lot of discretion with refusals, and some officers will spend 5-10 minutes talking to a person about their options. Some officers, and I've seen it, you ask 2 questions, guess what? That's 1 too many. I'm going to get a warrant. It's a refusal. We also have seen where somebody is confused or panicking a little bit. We had a case where a young woman is being read her Indiana implied consent, and she says yes, but then the officer gently grabs her arm to guide her towards the station. She pulls away. She said, I had no idea why he grabbed me. Well, guess what? Even though she said yes, her actions, per the officer, said it was a refusal. Again, court upheld this. So refusal bar is very low. So if you got a refusal, I don't want you thinking you're a bad person or anything like that. It's very easy to get a refusal in Indiana. And while it's easy to get a refusal, the penalties for refusal are very harsh. For a first-time offender, the penalty for a refusal is 1-year license suspension. If a person has a prior DUI, it's a 2-year license suspension. And that is in addition to the DUI suspension. So think about that. The refusal suspension is 1 suspension, and a DUI suspension is another suspension. So anytime somebody has a DUI with a refusal, there's 2 license suspensions. Does it sound confusing? It is confusing, and I'm going to let you know something. Attorneys regularly mess this up. How do I know that? Because I get calls constantly. Hey, Marc Lopez, I didn't hire you for my DUI. I should have. But now my license is really messed up and I want to get you on board. It's very hard to undo a situation where somebody has admitted guilt or been determined to be guilty and that person still has a refusal. It's almost impossible for me to help. So you want to do this right the first time. And the reason why it's so important to get it right the first time is because specialized driving privileges, this magical legal document that allows people to drive when they have a DUI, does not apply to refusals. It just does not. It specifically says does not apply to refusals. It is painful, so you have to deal with the refusal and you have to deal with it correctly. Now, how can we deal with the refusal? Well, there's 3 ways. Number 1, there can be a refusal hearing. And basically, you do a mini trial just to the judge explaining, hey, this was not a refusal. Because why? Usually, in my experience, arguing to a judge that a refusal is not a refusal happens when an officer misunderstands the technology of the breathalyzer or the blood test, or there's something just crazy going on. And it's very obvious in the video. Winning a refusal hearing is very challenging because you're basically looking at the judge, looking at the officer and saying, hey, judge, he was wrong. It can be challenging just because you're asking the judge to agree the officer was wrong. Judges don't always like doing that for lots of reasons. And I'm just telling you it's a hard sell. The second option is if the prosecutor agrees there's not a refusal. Sometimes you can bring up facts and arguments to a prosecutor and they can say, you know what? You're right, Marc. This is not a refusal. Let's figure something else out for your client. Now, a lot of times, though, prosecutors want to do that if the person pleads guilty, so they can kind of use the driver's license as an incentive for the person to plead guilty, make the prosecutor's life easier. So prosecutors aren't always jumping at the bit to get rid of a refusal at the beginning of a case. Sometimes some prosecutors in some counties, especially if the client has done something proactively, will agree to get rid of the refusal at the end. Number 3, and this is the worst option of all, in my opinion, prosecutor will not budge on the refusal. Well, then you can always at a guilty plea or after a trial, argue to a judge that getting the client driving is in the best interest of society. Now, that's a pretty vague term, and there's not a lot of case law, if any, describing what that is. It's judge's discretion. Now, what judges have told me and what I've seen firsthand, they don't really care if you are inconvenienced by not being able to drive, but how is society worse off by you not being able to drive? Do you take kids to and from practice? Do you work to support your family? Do you have a company where your ability to drive allows you to generate business for your employees? If you can't drive, is that going to cause you to lose your house and your kids to be on the street? So basically, how does society suffer if you can't drive? Again, no one cares about you. It's hard not to drive. We know that. And I'm going to tell you something. Judges are often not very sympathetic towards that argument. So those are the three ways to do that. Now, my firm handles DUIs, OVWIs, DWIs. They're all the same thing here in the central part of Indiana. And we deal with refuses all the time, whether it's Marion County, Hamilton County, Hancock County, Hendricks County, Johnson County, Boone County, Morgan County, Monroe County. We deal with these things constantly. So we know how judges respond to certain arguments, and we know what judges want to see at the beginning of the case. And I can't stress enough, being proactive at the beginning of the case is so helpful when dealing with refusals. If you're facing a DWI, DUI in Indiana, and there's a refusal involved, you want to talk to a lawyer, give us a call here at the Marc Lopez Law Firm, 317-632-3642. I know we can help you. But most importantly, I want you to remember to always plead the fifth.